Being fired or terminated from a job is never a pleasant experience, and if you've been offered a severance package, it can be difficult to know if you've been offered a fair and reasonable amount of money on your way out. It's important to understand that employers routinely take advantage of the fact that employees are unaware of how much money they're actually owed upon being terminated. Employers will frequently want to escape the potential liability of having to pay a terminated employee a large sum of money, and employers will try to accomplish this goal by pressuring the employee to sign a legal document called a full and final release. To incentivize and motivate the employee to sign the release, the employer will usually offer to pay what they believe is their minimum obligations, and then they will also offer some additional amount of money in exchange for the employee's signature on the release. Most people call these payments severance packages. What many employees don't realise, however, is that refusing to sign the release and instead speaking with an employment lawyer can often result in the employee receiving a significant larger sum of money from their former employer. However, before an employment lawyer decides to make any demands or file any lawsuits, the employment lawyer will need to determine if the severance package that has been offered is already fair in the eyes of the law. Perhaps unsurprisingly, the legal analysis to determine whether or not a severance package is fair is unfortunately not entirely straightforward, but it can be done correctly if you have the right lawyer with the right tools. In this video, we're going to explain some of the factors involved in determining whether or not a severance package is fair in Ontario. At KPA Lawyers, we're committed to making legal information accessible and easily understandable for the general public. We don't believe that the power of the law should rest solely in the hands of lawyers, HR professionals, and employers. So we've made this video to educate and empower employees in Ontario, and we hope that you find some benefit in this content. Although this video may feel somewhat long, remember that HR professionals and lawyers who represent employers have spent years studying these concepts, so they can use this knowledge to benefit employers at the expense of employees. If you want to be able to assert and understand your employment rights, then you'll need to carefully consider the topics in this video. You can pause this video at any time and rewatch any parts that you didn't quite understand the first time. Before we begin, we should mention a few limits on what we'll be discussing. We won't be focusing too much on federally regulated industries such as banks, airlines, telephone companies, and interprovincial transportation companies. These and some other industries are governed by Canada's federal laws rather than Ontario's provincial laws. Although many of the concepts in this video will apply to those industries, the focus of this video will be on employees in Ontario who work under Ontario's laws. If you aren't sure whether you work in a federally regulated industry, you can always contact us to discuss your case. We also won't be getting into any human rights issues, such as workplace sexual harassment, failure to accommodate disabilities in the workplace, and similar disputes. We already have some other helpful video content about those human rights issues, which are available for viewing on our YouTube channel at your convenience. Furthermore, this video does not apply to unionised employees. If you have been terminated in Ontario and you belong to a union, then you must address your concerns through your union. So, as long as you are not a unionised employee, you can feel free to continue watching this video. Let's start with where lawyers find the laws that govern employment in Ontario. There are two main sources, and they are the Employment Standards Act, or ESA for short, and the common law. The ESA is legislation that was created by the Ontario government, and the common law is basically judge-made law. Every time a judge makes a decision about a case, it becomes part of the common law, and other judges will use those decisions to decide similar cases in similar ways in the future. We'll make reference to the ECA and the common law in this video, which is why it is important to mention these concepts at this point. Now, let's move on to one of the most basic obligations that employers owe employees upon terminating an employee, which is the obligation to provide advanced notice of when the employee's last day on the job will be. Or alternatively, the employer must pay money to the employee, which is equal to the amount of money that the employee would have earned if the employer had given advance notice. For example, let's say Eric is employed by ABC Corporation, and Eric earns $5,000 per month. On January the 1st, Eric's manager tells him that ABC Corporation will be terminating his employment, but the manager assures Eric that Eric didn't do anything wrong. In other words, the termination is without cause. For the purposes of this example, let's just assume that Eric is entitled to 4 months of advanced notice. This is called the notice period. In this example, ABC Corporation has the choice to set Eric's last day on the job as April the 30th, or alternatively, they can send Eric home on January the 1st with $20,000, minus any statutory deductions, which is the amount of money that Eric would have earned during those 4 months. ABC Corporation can also choose to pay Eric on a salary continuance basis, which means that Eric would not necessarily receive all $20,000 up front, but would receive those wages at his regularly scheduled pay dates. Moreover, if Eric finds comparable employment before the end of his notice period, then ABC Corporation would then stop making further payments to Eric. In fact, if Eric sues ABC Corporation, then the law will expect Eric to apply his best efforts to find new employment. This is what lawyers would call Eric's duty to mitigate damages. In legal language, lawyers would say that Eric has the right to notice or payment in lieu of notice. However, it's important to keep in mind that the employer's obligation to provide notice or payment in lieu of notice does not necessarily apply if the employer has just cause for terminating the employee. Fortunately for employees, the Employment Standards Act states that an employee who is dismissed for cause could potentially still be eligible for notice and severance pay if the employee's misconduct did not amount to willful misconduct or gross neglect of duty. Despite that law being part of the ESA, employment lawyers who represent employees should still do everything possible to ensure that a judge does not become convinced that the employee was terminated for cause, because such a determination by a judge would have a significantly negative impact on the employee's case. To keep things simple, let's consider situations where the employee's termination was not for cause, which is very often the case. In such situations, you may be wondering how the law calculates the amount of advance notice that an employee is entitled to, or the amount of money that the employee should be paid during the notice period. Like we mentioned before, we can find the answers to these questions in the ESA and in the common law. It's important to keep in mind that the ESA simply describes minimum legal obligations, and just because an employer has met their minimum obligations does not mean that they have met their common law obligations, which often requires the employer to do a lot more than what is described in the ESA. So with that in mind, the ESA states that the employer must provide notice before the employee's termination, as follows. At least 1 week, if the employment was less than 1 year. At least 2 weeks, if the employment was between 1 year and 3 years. At least 3 weeks, if the employment was between 3 years and 4 years. At least 4 weeks, if the employment was between 4 years and 5 years. At least 5 weeks, if the employment was between 5 years and 6 years. At least 6 weeks if the employment was between 6 years and 7 years. At least 7 weeks if the employment was between 7 years and 8 years. Or at least 8 weeks if the employment was 8 years or more. You might be surprised to learn that the amount of notice or payment in lieu of notice, as calculated under the common law, can be significantly longer than the minimum lengths of time described in the ESA. However, we're going to start with dispelling a common myth about reasonable termination notice in Ontario. If you've been doing some of your own research online, you might have read that common law severance payments can be calculated using a short and simple formula, such as 1 month of wages for every year that the employee worked for their employer. Although it is convenient for employers and employees to settle on a simple formula during the course of negotiations, this is not how the law actually calculates how much an employer must pay an employee who is terminated from their job. The main factors that a judge will actually consider when calculating an appropriate notice period or payment in lieu of notice are the following: the character of the employment, the age of the employee, the length of time that the employee worked for the employer, and the availability of similar employment. These 4 factors are called the Bardo Factors, named after an old court case in 1960 called Bardo versus Globe and Mail Limited. Despite the case being many decades old, the case is still an important part of the common law today. However, there are also factors that judges will consider that go beyond the Bardo Factors. In Ontario, judges have also considered the following: the employee's role in the organisation, for example, middle management versus clerical workers, the amount of the employee's compensation, the type of profession, for example, IT specialists versus retail clerks, whether the employee's position was a unique and highly specialised position, for example, a radiation safety officer for a facility that manufactures nuclear medical equipment, the years of experience the employee had in his or her industry itself, which is a wider question than simply the length of time the employee worked for their most recent employer, the number of years of post-secondary education the employee had, whether or not the employee has an illness or other medical reason that would make it difficult to find a new job, the industry that the employee was working in, for example, mining versus medicine, whether the employee moved to a different city or town solely for the employer, upon accepting the job or even working for the employer for some time, whether the employee received a promotion or bonus for good performance in the year leading up to termination, whether the employee received a negative performance review or documented formal warning, whether the employee was already actively looking for a new position in the 3-month period leading up to the termination, whether the termination was solely because the employer was experiencing financial difficulty and for no other reason, and lastly, whether the employer originally commenced employment relationship by enticing the employee away from their previous job. This is because leaving a good job for a new employer only to be fired by that employer can be frustrating for employees, and the law recognises this. When all of these factors are considered, some employees might be entitled to 1 or more years' worth of notice or payment in lieu of notice. But every case is ultimately decided on the basis of its own unique merits and circumstances. At this point in the video, it's important to mention that clever employers will often use employment contracts at the beginning or even during the employment relationship that contain language which significantly reduces an employee's rights upon termination. The idea here is that the employer and employee mutually agreed to certain termination arrangements in writing, so those arrangements should be followed at the end of the relationship. The employer cannot use an employment contract to reduce an employee's rights to anything below what is described in the ESA, but an employer can remove an employee's common law rights using an employment contract. Unfortunately, employees usually reach out to employment lawyers when they are being terminated and rarely do so when they have been presented with an employment contract. This is how employers often get away with including such aggressive language in their employment contracts. However, not all paragraphs and clauses in an employment contract will be recognised as valid in court. Poorly drafted contracts, ambiguous clauses and contracts that violate the ESA will not be recognised by a judge. In fact, in June 2020, the highest court in Ontario, known as the Court of Appeal, set a precedent that significantly improved the rights of employees in Ontario and increased potential liability for employers across Ontario. Since that case was so important, we're going to spend a few moments describing that case now. That case is called Waxdale versus Swegen North America Inc. The case involved an employee, Benjamin Waxdale, who had been terminated from his employment. The central issue in the case was the interpretation of Mr. Waxdale's employment contract. The contract contained a sentence which stated that no notice or severance would be provided if the employee was terminated for cause. However, that sentence was invalid because it was inconsistent with the ESA. Like we mentioned earlier in this video, according to the ESA, an employee who is terminated for cause may still be eligible for statutory notice and severance pay if the employee's misconduct did not amount to willful misconduct or gross neglect of duty. The interesting thing about the case was that Mr. Waxdale was not terminated for cause, so the invalid part of the contract was not even something that his employer was trying to use. However, Mr. Waxdale's lawyers argued in court that since the for cause part of the contract was invalid, the other parts of the contract dealing with without cause terminations should also be invalid as well. This was important to Mr. Waxdale because the for cause part of the contract limited the amount of money he would receive, and he would receive a larger amount of money if the common law calculations were used instead of the calculations in the contract. It doesn't take a lawyer to realise that this was somewhat of a bold argument. After all, it would seem unfair to the employer to disregard any valid points of an employment contract just because a separate and unrelated part of the contract was invalid. However, the court ultimately decided the case in the employee's favour. Specifically, the court said, recognising the power imbalance between employees and employers, as well as the remedial protections offered by the ESA, courts should focus on whether the employer has, in restricting an employee's common law rights on termination, violated the employee's ESA rights. While courts will permit an employer to enforce a rights-restricting contract, they will not enforce termination provisions that are in whole or in part illegal. Don't worry if the legal analysis that we're describing isn't obvious at first. The main point that we're highlighting here is that, as of June 2020, the rights of employees when it comes to termination pay were greatly improved by the courts. And this is good news for employees, while employers should proceed with caution. Now let's move on to another concept called moral damages, which is an additional amount of money that an employer might be required to pay to an employee in certain situations. A court might order an employer to pay moral damages if the employer has engaged in conduct that was in bad faith by being, for example, untruthful, misleading, or unduly insensitive. Moral damages are intended to compensate you for mental distress that has been caused by the bad faith manner by which you were fired from your job. However, it's important to keep in mind that a court will not require an employer to pay moral damages just because the employer decided to fire the employee, even if the decision to fire the employee was unfair. There must be something more than just the termination to lay the groundwork for moral damages. Even after considering all of the information in this video, you might be wondering how to access a lawyer, given the fact that lawyers have a reputation for being expensive. For this reason, many clients prefer to find a lawyer or law firm that accepts cases of a contingency fee, which means that the lawyer is only paid a portion of whatever money they can win for you. However, paying a lawyer in this way has the potential to negatively affect the outcome of your case, unless you are able to find a very honest, ethical and hard-working lawyer. To learn more about legal fees and how they can affect the way your lawyer works, we recommend that you watch 2 of our other videos. How do legal fees work? And can lawyers actually get in the way of resolving legal disputes? It's important to remember that this video is not intended as legal advice, and you should always speak with a qualified employment lawyer if you have questions about any of the topics discussed in this video. Employment law is a vast and complex area of law in Ontario, and it would be almost impossible to describe it all in one YouTube video. You can support our efforts to make free legal information available to Canadians by liking and following KPA Lawyers on Facebook and subscribing to our channel on YouTube. If you'd like to speak with a lawyer in Ontario, feel free to visit us at kpalawyers.ca.